What are the defense strategies in a TBI case? During litigation to recover compensation for a brain injury, the defense counsel may apply numerous tactics to discredit the victim and the injury. Such strategies include emphasizing the lack of reporting of the brain injury in early medical records, emphasizing the fact that the victim may have said they were okay at the scene of the incident, emphasizing the fact that the incident may not have been sufficiently violent, or emphasizing the fact that there may be a prior history of brain trauma. In order to refute the fact that there was no early reporting of the brain injury in medical records, plaintiff's counsel should introduce publications by the Center for Disease Control which expressly state that patients must be specifically questioned as to whether they have had an injury or accident. This is important because some patients may not mention the injury-causing accident to their physician at all. The publication can be admitted as evidence if the plaintiff's expert establishes it is a reliable authority. The publication can also be used in cross-examination of the defendant's expert. The federal government's publication may also be admitted by judicial notice. Defense counsel may also point to prior educational and work records to show there is no serious impact from the alleged brain injury. Defense counsel may claim the injured victim's doctors are hoodwinked and cannot be trusted. Similarly, defense counsel will have its retained neuropsychologist testify that the plaintiff had premorbid functioning. Defense counsel will show plaintiffs poor educational transcripts, such as repeating of grades or failure to obtain a general education development diploma or a GED. The occupational levels, the presentability measures, and evidence of pre-existing deficits or learning disabilities. The defense will attempt to introduce sub rosa and surveillance evidence to expose an allegedly dishonest plaintiff by using advanced video editing technology to make a truly injured plaintiff appear to be not injured or less injured. Defense counsel will also attempt to break down the injured victim at a video deposition. Defense counsel may also attempt to show that the plaintiff was taking certain medications that can have a masking effect, which can alter the result or outcome of certain neuropsychological tests and make them faulty. This is an important challenge facing plaintiffs who take certain neuroleptics or antidepressants. Overall, the defense counsel may try to show the jury that the injured victim is malingering and lying about the injury. However, in order to prove malingering, elements must be satisfied. If injured victim's own treating physicians have never suspected the victim of malingering, then plaintiff's counsel can argue that the treating doctor's opinions should be persuasive and controlling. Defense counsel's tactics can be overcome if the plaintiff's counsel takes the necessary steps to show the jury that the injured victim plaintiff is credible, the event was violent, the mild traumatic brain injury criteria are satisfied, and the impact on the injured victim's life before as compared to after the injury. Plaintiff's counsel should also present collateral witnesses and corroborative medical evidence. It is important for the plaintiff's counsel to present the case in a way that grabs the jury's attention, to build momentum throughout the trial, and to show that the defense is cynical. What if the TBI victim has a pre-existing condition? Many times, when pursuing a personal injury claim for a traumatic brain injury, the defense counsel will try to argue that the plaintiff had a pre-existing condition that included the same symptoms and complaints as the current brain injury that is the subject of the litigation. In doing so, the defense will attempt to limit the damages recoverable for the plaintiff. In dealing with this argument, the legal doctrines of an eggshell plaintiff, exacerbation of a prior condition, and a substantial causation are on point. Also important to note, the federal government's acute concussion evaluation states that prior history of anxiety or depression is a risk factor for protracted recovery. Plaintiff's counsel should present to the jury that the injured victim was an unusually susceptible plaintiff and therefore prone to being injured. The foundational legal principle is the defendant takes his plaintiff as he finds him. Simply, the plaintiff should not be prejudiced for being in a condition that makes him more susceptible to being injured. The defense neuropsychological examination. The defense will often demand a neuropsychological examination of the injured victim by a neuropsychologist of their choosing to discredit the injured victim. The injured victim will be required to submit to hours of adversarial examination outside the presence of counsel. Audio taping the examination is permissible, but no attorney or third parties are allowed to be present during the examination. Moreover, unless the parties agree, leave of court is required to obtain a neuropsychological examination. However, a motion shall be granted for good cause, which requires a showing of relevancy and specific facts justifying the discovery. The parameters of the examination should be clearly defined, either through agreement by counsel or by a court order. An order helps minimize potential misunderstandings. It is important to establish clear timeframes and other limiting parameters to protect the plaintiff's privacy. There must be an agreed list of tests to be performed. The defense is not entitled to a psychological test without a court order. Any non-standard testing should not be allowed. It is important to consult with the victim's own neuropsychologist on what tests should be agreed to. The doctor may want to perform the Minnesota Multiphasic Personality Inventory, the MMPI test. However, the MMPI is a bad test. It will come back that the victim is exaggerating the injury. In fact, people with severe brain damage can score high on the test. Within 30 days of the examination, the plaintiff may demand the neuropsychologist to produce a detailed report setting out the history, the examination findings, test results, diagnosis, prognosis, and conclusions. The defense psychologist's raw testing data is sent to the injured victim psychologist for review, including the scoring, interpretation, and computerized printouts. Deposition of the defense expert. To cross-examine the defendant's neuropsychologist, the plaintiff's counsel should research the expert and obtain all their published material because many times they will contradict their own opinions. It is also important to obtain what the defendant's neuropsychologist believes is authoritative on the issue. If the neuropsychologist refuses to disclose this information at the deposition, it is practical to just look around the deponent's office to see what publications are in the office and read it into the record during the deposition. Obtain all the defendant's neuropsychologist's past depositions and for what party, plaintiff or defendant. Also, plaintiff's counsel should consult with the plaintiff's expert in order to be prepared for taking the deposition of the defendant's expert. In addition, it is always good to question the expert during deposition whether they have played any sports in the past and whether they are aware that injuries can result, that people can get hurt. The rationale is to paint the expert as a dangerous person to society because they are reporting people are not hurt when in fact they actually are, for the purpose of being paid money. Also, it is good to question the expert if they have in fact ever seen the plaintiff and for how long. Many times the doctor may not have even seen or cannot recognize the plaintiff, particularly after time has passed since conducting the examination. The expert should be questioned on how much they are paid per hour. If videotaped, the silence after asking this question is very powerful to the jury. These type of questions should be asked at the end of the deposition so that the expert is not closed off early on during the deposition. A powerful line of questioning to ask the expert is it true that by definition, a mild traumatic brain injury will not show up on film? Loss of consciousness is not required for a traumatic brain injury. Do you need physical impact to cause traumatic brain injury? Or do you agree that the plaintiff suffered a mild traumatic brain injury? Essentially, the real argument in a traumatic brain injury litigation is over the residual damage to the injured victim. A residual injury is one that is long-lasting or has a permanent effect on the victim. If the injured victim has lingering or permanent residual injuries, the settlement value or verdict may be higher, particularly if the injury impacts the victim's ability to earn an income. A key inquiry in the litigation will be, what is the industry standard for believing an expert's report over the treating physicians? Moreover, during the defense expert's deposition, the expert should also be questioned about the Hippocratic Oath. Do you owe the Hippocratic Oath to the plaintiff, who you are not in fact treating? The implication is that the expert is being paid big dollars to make up an opinion. Other questions to the expert that should be considered include, have you ever had your own work peer-reviewed by someone above you at any time in your career? Is it okay to disagree with these reports? Has your work ever been disagreed with?